Ryan Eberlin, last name Eberlin.
I always say it wrong. I say the Eberlin. I'm sorry.
It's all right.
You are a member of the Orange County Sheriff's Department?
Yes, sir.
Were you so employed in July of 2008?
Yes, sir.
On or about July the 15th, sir, were you dispatched to a residence on Hope Springs Drive?
Yes, sir.
You know who lived there?
The Anthony family.
Had you ever had any contact with the Anthony family prior to that time?
No, sir.
Sir, when you arrived, did you participate in an overall just kind of controlling the scene and what's going on and asking questions?
Yes, sir.
And at that point in time, sir, did you observe a white Pontiac Firebird automobile?
I did, sir.
Did you notice any particular odor about that car when you were looking at it?
No, sir.
In addition, sir, after you had some interview there, did you have occasion to put handcuffs on Caylee Anthony?
Yes, I did, sir.
And were you subsequently instructed by Sergeant Hosey to remove the handcuffs?
Yes, sir.
Thank you. No further questions.
Cross-examination.
Thank you. Deputy, you were the junior deputy on the scene, so to speak?
Yes, ma'am.
Okay, and Sergeant Hosey was there as well?
Yes, ma'am.
The handcuffing of Ms. Anthony was for 2 or 3 minutes?
Yes, ma'am, approximately.
Okay. And after that, she was immediately released and went back into her house and was free to go about her business, correct?
Yes, ma'am.
Why was Ms. Anthony handcuffed?
While Casey was inside the house, her mother, Cindy, had approached me while I was outside and informed me that Casey had stolen her.
Hearsay?
Open the door, Your Honor.
Still hearsay.
Exception to the hearsay rule.
Your Honor, the complainant formed the basis for probable cause for this individual.
That should be sidebar.
Okay. Okay, members of the jury, there's going to be a brief legal matter we need to take up outside of your presence. We will get back with you as quickly as possible. Maybe seated. Okay, Ms. Burdick, you may continue.
All right, Deputy, can you tell the court why you put handcuffs on Ms. Anthony?
Cindy Anthony had approached me while Casey was inside her residence while I was on scene, and came out with receipts stating that Casey had stolen her credit card and made fraudulent purchase with that credit card. And she wanted to press charges for or against Casey. I then went inside the house, detained Casey, and brought her into my car and was going to continue the investigation of the fraudulent use for credit cards. At that time, when I placed her in a car, that's when Sergeant Hosey had told me, we're not concerned about the fraudulent use of the credit card at this time, only the kidnapping that we were investigating, and informed me to take her out of cuffs, which I did, and she went inside.
All right. Now, as it relates to the timeline of events, this happened after Ms. Anthony did her written statement for you at 1 in the morning, correct?
To the best of my recollection, yes.
Okay. But before at the time, Corporal Melich arrived at 4 a.m.
Yes.
Okay. That's all we have for the proffer.
Okay, argument. Mr. Mason and then the state.
I don't think it's read and or the instruction to the jury that she's not on trial for guilt.
I'm sorry, Mr. Mason, can you repeat that last part?
What did you not hear? All of it?
Repeat it again, Mr. Mason.
I'm having to read you.
Not on trial for any other.
Not on trial for any of those allegations, whether it's credit card or car or otherwise.
Okay. The defense raised the issue of the handcuffs being placed on Miss Anthony, and then elicited questions that the officer removed the handcuffs without any particular explanation as to the reasons why, which opens the door for this particular testimony. The court will fashion a jury instruction to deal with this. Just a second. Okay, this is the instruction that I propose to give. The evidence you're about to hear concerning the reason for the handcuffing of Miss Caylee Anthony is solely to explain why the deputy did what he did, and is not to be considered for any other purpose. The defendant is not on trial for those acts, and you should not consider it for any purposes except to explain why the deputy did what he did. Any additions, deletions from that particular instruction? State.
No, Your Honor.
Okay, this is the final version. The evidence which you are about to hear concerning the reasons Miss Caylee Anthony, the defendant, was handcuffed is to solely explain the reasons why the deputy took those actions, and is not for any other purpose. The defendant is not on trial for those acts, and you should not consider it for any other purpose except to explain why the deputy handcuffed the defendant. Okay, let's return to jury. Stay recognized, President of jury.
Yes, Your Honor.
The defense. Ladies and gentlemen, the evidence which you are about to hear concerning the reasons Miss Caylee Anthony, the defendant, was handcuffed is solely to explain the reasons why the deputy took those actions, and is not for any other purpose. The defendant is not on trial for those acts, and you should not consider it for any other purpose except to explain why the deputy handcuffed the defendant. You may proceed.
Thank you. Deputy, you had indicated Ms. Anthony was handcuffed for a very brief period of time, correct?
Yes, ma'am.
Okay. Was that done after she had provided the written statement that you countersigned for her?
Yes.
Okay. After that occurred, Mrs. Anthony, Cindy Anthony, came to you when you were outside and indicated that she wanted to press charges against her daughter Caylee for the fraudulent use of her credit card, correct?
Overruled.
Yes.
Okay. And in order to further that investigation, you went into the house, handcuffed Ms. Anthony briefly, at which point in time your supervisor, Sergeant Hosey, told you that he wanted the handcuffs off.
Yes, ma'am.
At that point, Ms. Anthony was free to go back into the house while the investigation continued into the alleged kidnapping of her daughter, Caylee, correct?
Yes, ma'am.
Corporal Melich showed up at least an hour or more after that, correct?
I don't recall the gap in time, but
Was it after?
yes, the detective showed up after that.
All right. And he was not present for this exchange between you and Cindy Anthony, correct?
No, ma'am.
Okay. Or you and Caylee Anthony, for that matter.
Correct. No.
Okay. And then once Corporal Melich arrived, you were not involved in any way, shape, or form in the taking of additional statements from Ms. Anthony, either at her residence at 4 o'clock or so that morning, correct?
Yes, ma'am.
And you were not involved in taking any statements from her on July 16th at Universal Studios, correct?
Correct.
Thank you. That's all I have, Your Honor.
Redirect.
No further questions, Your Honor.
May the deputy be excused.
Yes.
Thank you, deputy. You may be excused, sir.
Eric Edwards, ERIC, EDW, ARDS.
You may proceed.
How are you employed, sir?
With the Orange County Sheriff's Office.
What is your job? Oh, hold it. What was your job in July of 2008?
I was in the Orange County Sheriff's Office Homicide Unit acting as a corporal.
Are you one of the lead detectives in the investigation, in this case, State of Florida versus Caylee Anthony?
I assisted a great deal, yes.
I want to direct your attention to a narrow subject, sir. Do you know Alinda Tonelli?
Yes, sir, I do.
Who is she?
She,
The relevance, Your Honor.
Approach the side. Okay, ladies and gentlemen of the jury, there is another legal matter that we're going to need to take up outside of your presence. I will get back with you as soon as possible. Please do not discuss this case among yourselves nor with anyone else. Okay, let the record reflect that the jury is outside of the courtroom. Mr. Mason, you may proceed with the proffer.
Thank you. Mr. Edwards, I ask you, sir, if you knew Linda Tonelli.
I met her through the investigation, yes, sir.
And who did you learn, what did you learn was her involvement initially in this case before you did further things with her?
I'm sorry, sir, I can't hear you very well.
What did you learn about her first as far as this case is concerned?
She was brought to my attention by an individual by the name of Lori Cree that was a volunteer for Texas EquiSearch. And I don't remember the date off the top of my head, but at any rate, I want to say it was about the time, somewhere in the December timeframe when we visited Texas EquiSearch. And while we were out there, I received a phone call, I want to say, from Lori Cree. And that's when she brought Linda Tonelli to my attention, I believe the first time. I could be wrong on that date. But at any rate, from that conversation with Lori Cree, Linda Tonelli was a volunteer at the Kid Finders tent and spent a great deal of time there assisting with the Kid Finders and the Anthonys, or George Anthony, anyway. Does that answer your question?
Yeah. Did she coordinate one of the tables in the overall, the volunteers searching for Caylee?
I know that based on the communication we had with her, because John Allen and I had interviewed her shortly after returning from Texas, I think she was in charge of maintaining the volunteer sheet or something of that nature.
Did you have occasion to discuss with her, sir, any issues regarding duct tape?
I did. I showed her a photograph of a image that had been provided by one of the local media outlets. I'm not sure which. And because that, I believe, now that you say that, I believe that's what Lori Cree had said, that Linda may have even brought to her attention, that she recalled that Mr. Anthony brought some duct tape to the kid finder's tent at one point. And I'm not sure that was one of the reasons that we interviewed Ms. Tonelli.
Did you show the picture of the duct tape, in fact, to Ms. Tonelli?
I'm sorry?
Did you show the picture, the photo of the duct tape?
I showed I can't recall if it was a video and we captured one image of that, or if it was a download of one photograph. I can't recall off the top of my head, but I know we did show her it was kind of a fuzzy image of one of Caylee's missing pictures with the duct tape on it at a tent, is my recollection.
Yeah. And did she identify seeing the duct tape with George? Mr. Anthony, excuse me.
She, and I'm going off memory here, she didn't specifically say that's the tape that I can recall. She just described a very strong tape for whatever reason. And Mr. Mason, without looking at that transcript again, I can't recall everything off the top of my head, but I would have brought to someone's attention, or I think it would have been more of a deal if she said, that's definitely the tape, because it's very, you can identify it due to the writing or the markings on it. So that doesn't stand out in my mind.
After the remains were found, did you, in your official capacity, contact Miss Linda Tonelli?
Do you have something that could refresh my memory? Because I know there was another time when John Allen and I had driven out and met her and contacted her again because of some correspondence or communication she had with the Anthonys.
Do you remember, sir, going to her home in around March of 2009?
Yes, sir.
And did you at that place and time discuss with her placing eavesdropping equipment in her house, like a bug on a lamp in the living room?
Quite possibly, yes, sir.
And did you do that, sir, for the purpose of getting her to invite George and or Cindy over to speak with her and try to capture their conversation?
My recollection of that is they were asking to meet with her and to talk to her. And I believe what she had told us at that point was she had visited the Anthony home and told them that we had met with her. And after that point, she had been receiving communication some way, somehow from the Anthonys. And our concern at that time was what they would maybe ask her to say. Yes, sir.
You wanted to capture their conversations with Miss Tonelli?
If it was made available, yes, sir.
All right. And in fact, sir, did she ultimately decline? That is, Miss Tonelli declined to do that?
I don't recall that off the top of my head. I recall her being somewhat uncomfortable because she would have had to get her husband's permission, and she didn't want to, maybe that came across a little too intrusive to her personal life, is what I remember. She didn't say no. My impression was she was willing to entertain other ideas. However, that one, she wasn't really a big fan of that.
So you never did it?
That's right.
Thereafter, did you contact her again?
That would be the third time in the...
At Lowe's?
Correct.
And you and Detective John Allen and Detective Yuri Melich appeared there, do you remember?
No, sir. It was just Sergeant Allen and myself is what I remember.
Just the two of you?
Yes, sir.
And did you at that time ask her if she would in fact wear a concealed wire microphone on her person?
We may have entertained that conversation. And
was the purpose of that so that she could further try to capture candid conversations with Mr. George Anthony and or Cindy Anthony?
Possibly, yes, sir.
And did she do that?
She did not. The window of opportunity never made itself available.
That would be the proffer with respect to that aspect of his dealing with Ms. Tonelli, Your Honor.
And Mr. Mason, you have any questions, on the proffer?
I do not.
Aware, sir, of any voicemail messages left on Ms. Tonelli's phone by Mr. Anthony?
By Miss Anthony. I believe it was Miss Anthony, called Miss Tonelli. She allowed us to retrieve that from her phone. I believe it was Miss Anthony. Do you have a transcript I can review?
No.
Off the top of my head, I want to say it was Cindy Anthony that called and left Linda a phone message.
Do you recall the substance of that phone message that was left?
I believe I would be more comfortable answering that question with a review of a transcript. I know that.
Did you cause a transcript to be prepared of that phone message?
I believe Sergeant Allen recorded that contact on that date, so he would have to answer that question. I myself am unfamiliar with it.
Okay.
All right, Mr. Mason. What material fact does this evidence tend to prove or disprove, or what relevancy this has to the theory of defense?
How much time do I have?
As much time as you can take.
Judge, as I said before, it does reveal only that the focus of the investigation was otherwise directed not just at the defendant on trial, but at others because of the processes of the law enforcement investigators. As to being able to establish a material fact in the absence of the recording, it doesn't.
Part two to the question. What relevancy does this have to the theory of defense?
The theory of defense, as presented to you earlier, deals in multiple levels, but as far as this would be concerned, the dysfunctionality and the circumstances involving what happened after the accidental drowning and who did what in an effort to conceal or cover that up. And the investigation carried on in that regard, and it goes to the theory of defense to suggest that the detectives involved in the case were so interested in following that road that they asked a woman to wear on 2 occasions a wire or concealed interception of communications to try to find out and get incriminating statements from the parents.
And since the next witness is out there, were they successful in getting incriminating statements?
You said, did they?
Were they able to get?
No, sir.
Okay.
No, sir, they were not, because she actually, after being requested twice, she declined to do it. What she otherwise would only be able to testify to, which is what we already have in evidence about the duct tape.
Okay. Thank you. State.
Your Honor, as I argued at sidebar, it is obvious from the proffer, as well as what was argued at sidebar in open court, that this line of questioning is designed only to invite the jury to speculate on the motives of law enforcement without actually ever asking what their motivation was to do something, because their motivation would be irrelevant, because it does not relate to any of the material facts regarding Caylee Anthony's guilt or innocence. This is particularly emphasized by the fact that no evidence was obtained as a result of this law enforcement endeavor, and therefore the only thing left is the motivation. And that is not a subject that is relevant or material for this jury to consider at this juncture.
Okay.
One last comment.
The court reporter would appreciate it if you'd be by microphone.
It's interesting, the objection based on speculation, yet we're asked to speculate that the murder weapon was duct tape and the child suffocated from duct tape.
Mr. Mason,
Go to the argument.
Ms. Train,
Yes.
there's no jury in here. And I can determine, I think I have enough experience to understand what goes to an argument and what does not go to an argument. So there's no jury. So the objections about arguments, folks, is just a needless waste of time. So let him finish his argument.
I have nothing else to say, Your Honor.
Okay. State anything else it would like to say in concluding remarks?
No.
Okay. The Florida Supreme Court in the case of Wright versus State, 19/7 edition, 3rd page 277, the 2006 decision of the Florida Supreme Court, said that it is within the trial court's discretion to determine what is relevant evidence. It goes on to say that the requirement for admissibility of all evidence is relevancy. And it talks about the evidence code. And the definition contained in 90.401 of the Florida Evidence Code defines relevant evidence as evidence tending to prove or disprove a material fact. It is quite evident by the proffer of the testimony of the detective that this evidence does not go to proving a material fact. The second possibility is its admissibility under the theory of the defense. The theory of the defense that has been advanced at this time is that the victim in this case died as a result of an accidental drowning, and the bizarre behavior or different behavior on behalf of the defendant after this was caused by certain events that the defense espouses. This particular evidence does not go even to the theory of defense. Therefore, the state's objection to this particular evidence as not being relevant will be sustained and is not admissible under 90 versus 401 or as a theory of defense. So the deputy's testimony is proffered for purposes of the record. Do you have any other questions you would like to ask him on any other topic other than the bugging of Mr. and Mrs. Anthony?
Not at this time, Your Honor. We'll be following.
Okay, Deputy, you're hereby excused. Detective, I'm sorry. Do you still intend to call the next witness?
We will call Ms. Elliott briefly.
Okay. Is it for a different purpose Or is it for the purpose of the proffer?
Different purpose. Although he did reference part of it, I'll take it out, duct tape.
Yeah, the duct tape. Okay. I just want to make sure that we don't have to send these folks out again on the Pop-Tart route. All I'm asking is if there are some matters we're going to need to take up and have a sidebar, I would much rather do it now than to have the jury come back in and we have to go through this exercise again. I have no idea who this witness is and what she's going to be asked to testify about.
Step out.
Yes, sir, you may. We'll be at ease.
I want to make sure she's living.
Okay. Okay, the court reporter is ready. Is the defense's real time working? Mr. Baez, is your real time working?
Yes, sir.
Okay.
Your Honor, apparently the only evidence to be elicited from this next witness is that at some unknown date and time at a command center, the witness saw Mr. Anthony with duct tape that cannot be further identified. I believe that's what was confirmed by now Sergeant Edwards. Therefore, that testimony is of no material value, and we would object when they attempted to elicit that. So I wanted to bring that to the court's attention now. If she could, in fact, say that there was a specific brand of duct tape that she recognized that he had on a particular date relevant to this time frame, I would not object, but it does not appear that the witness is going to be able to do that.
But she can say it's duct tape.
Okay.
Okay.
That's what I understand her to be able to say, but that doesn't establish any relevance.
You're saying it's not relevant because she cannot say what brand of duct tape.
Or identify when shown a specific brand that was what was used.
So you're saying whenever the state of Florida sees someone with a knife or a gun and can't say what type of gun it was or knife, and that the victim in a murder case was killed with a gun or knife, that evidence is not admissible?
Not unless we can tie it into some relevant time frame that would establish its materiality.
Okay.
The fact that someone possessed a gun or a knife at a particular point in time would never be admissible unless it could be tied in to a relevant time frame.
Well, isn't she going to testify it was at the volunteer tent?
Yes, sir.
Then that does not affect its admissibility. It affects its weight and whatever weight they would give. But I kind of think the defense bar would be very interested if the state would agree to that proposition of law in all of its cases. Because most of the time, most witnesses can't tell you a serial number or whether it's a revolver or a semi-automatic. All they can tell you is somebody stuck a gun in their face and robbed them at gunpoint. But
okay,
that's a debate for another time.
Yeah.
That is admissible. Ready? All right, let's return to jury.
Linda Tinelli, Linda Tinelli.
Good afternoon, Mr. Nelly.
Hi.
Do you know George and or Cindy Anthony?
Yes, I do.
You tell us when and how you first met them?
When I heard Caylee went missing, they had a command center. I went down to the command center on Publix at Lake on the Hill in Chickasaw and offered my help as a volunteer.
You were a volunteer helping to coordinate the search issues, is that it?
No, I coordinated the table where they gave donations and handed out T-shirts and pins and bracelets.
And did you volunteer at that command center on occasions with Mr. George Anthony?
Yes, I did.
And at that time, those times and places, that was been during the late summer, early fall of 2008, would that be correct?
From towards the end of July till December. The last day was December 8th.
Okay. During that period of time, ma'am, did you observe Mr. George Anthony having duct tape?
Yes.
Duct tape.
I'm sorry.
Yes?
There was duct tape at the table, yes.
Okay. And do you know how it was used at that time and place?
Yes, we had like plastic tablecloths, and we would like take the tape and hold the tablecloths on because it was windy sometimes and they would blow. And we also put posters up with them of the missing children.
Okay. When you say we, does that include yourself?
Correct.
And Mr. Anthony?
Yes.
Okay. Thank you very much. Those are the only questions I have. You were talking about the wind blowing the tablecloths and so forth?
Correct. They were plastic tablecloths.
What, if anything, did Mr. Anthony do about that in your presence?
Well, we would like tape the tablecloths because they would go like around the tables, and we would just tape them underneath to hold them so they wouldn't blow off.
Thank you very much. That's all.
Cross-examination?
None.
May the witness be excused.
Yes.
Thank you, ma'am. You may be excused.
My name is Yuri Melish, Y-U-R-I-M-E-L-I-C-H.
You may proceed.
Thank you, Your Honor. May it please the court. Good afternoon, Detective Melich.
Good afternoon, sir.
Detective, as previously testified, you are the lead investigator in this case.
Yes.
And pretty much that means you're in charge of the case.
I have a supervisor I answer to.
Right. But you are the, I guess, the coordinator of everything?
For most of it, yes, but I also have a supervisor who has input on certain decisions that are made, and he has a supervisor that he answers to as well.
And were you first called out on July 15th, 2008?
I believe it was after midnight. Would that have been July 16th?
16th, I apologize.
Yes.
Okay. And when you were called out, you were made aware of the smell of the Pontiac Sunfire pretty early on when you first arrived.
I don't know if I would say early on. As I testified to before, at some point somebody at the house had mentioned the smell in a car.
Okay. And that somebody was George Anthony, wasn't it?
Yes, correct.
Okay. And the next day, well, let me stop you there. Let me stop there. You didn't do anything with that information?
No, not until later that day.
Okay. And when you say later that day, you mean you were there at nighttime or early morning hours, late?
I don't believe I returned that night. We had the car brought to our central operations center later that night, later on the 16th.
Right. What I'm saying is you arrived in the early morning hours on the 16th.
That's correct.
Then later on, after you had spent several hours there, you left.
I don't know if it was several hours, but after a short period of time, enough to do the interview, yes, I left, came back, and then left again.
How much time did you spend at the Anthony home in the early morning hours of the 16th?
My initial arrival, to include the time it took to take the original tape statement, maybe a little over an hour.
And then after that?
Just long enough to drop Ms. Anthony home after she showed me the locations.
And then as soon as you dropped Casey Anthony off, you had more interaction with Mr. Anthony, correct?
Yes, at the driveway as I was about to leave.
Okay. Okay. He wanted to speak with you privately.
I don't know what he wanted, but ultimately he talked to me at the car as I was at the end of the driveway. I was still in the car. He approached the car.
And the purpose of his conversation with you is to focus a little more on Caylee, correct?
Objection. He's asking the witness to speculate on someone else's state of mind.
Sustain.
What was the purpose of that meeting?
Same objection. He's asking the witness to speculate.
He can answer from his perspective.
I don't know what his purpose was. My purpose was simply to drop her off and then go do my investigation.
Did you obtain any more information from that private meeting that you had with Mr. Anthony?
Just what I noted in my report, what he'd said.
Okay. And then the next day, I want to say you left in the early morning hours, around 7 a.m.?
Approximately, yes.
Okay. And then you met with Miss Anthony around noon that same day?
Yes, at Universal Studios.
Okay. And how many police officers were there while you were at the Anthony home?
I can recall 2 uniformed officers and myself, not to say that there wasn't another uniformed officer present, but I wasn't really paying attention to the uniformed officers. I was paying attention more to the Anthonys and Miss Anthony.
Did you see Sergeant Hosey there?
Yes.
Did you see Adriana Acevedo there?
I don't recall who else I saw aside from Sergeant Hosey, and I recall him because I believe I had a conversation with him when I arrived on scene. I believe that was him.
Have you at any time come to realize there were approximately 7 or 8 officers there that evening?
I wouldn't believe that there were 7 or 8 officers, no. But again, I wasn't paying attention to the officers there. I believe if there had been 7 or 8 police cars, it would stand out, but that does not stand out.
Did any officer that was there that evening, whether you saw them or not, later on come to you or advise you at any time that the car should be confiscated or crime scene should be called out because the car smelled?
I don't recall.
Stay.
Now, after you actually didn't go confiscate the car until after Miss Anthony was arrested, correct?
Correct. I had already made arrangements with Mr. Anthony, and another detective went to take the car and items that were inside or had been inside the car.
So the process of how this all went down was you showed up that evening. The next day you met with Miss Anthony. You arrested Miss Anthony, and then you went and looked for the car or confiscated the car.
Not entirely correct. It was all one day. This all happened on the 16th. So when you're referring to the next day, it's all still the same day.
Okay, forget the days. But the sequence of events goes like that, correct?
That's correct.
Okay. And it wasn't until she was under arrest that you decided to look for evidence in that car.
That's correct.
Okay. And the reason you arrested Caylee was because you thought she might harm herself.
The reason I arrested her was because she had the elements of the crimes what she was arrested for. Part of my determination on to make an arrest, yes, I had already explained and I had testified to that I was concerned that she may hurt herself. And this is based on my opinion on another case that was in the media at the time.
Okay. And because that other case from the media at the time ran through your head, this was what kind of facilitated you arresting her at that time?
Again, she had already fulfilled the elements of the crimes I arrested her for. That's one of the thoughts I had at the time that I won't deny has helped me with the decision on whether to make a physical arrest or do another option. But yes.
Okay. And now, after she was placed under arrest, the focus of the investigation focused heavily on the car then.
The focus of the investigation was always to find this missing child or kidnapped child. Yes, we did focus our investigation towards the car, but it wasn't the sole point at that point or at that time.
And as part of your investigation, obviously you wanted to do a thorough job.
Yes.
Okay. And that would include looking at every possible scenario.
Correct, but keeping in mind that we were going off of what we were told happened. And that included that this child was kidnapped by a known individual, and we had all these other names to go with it.
And you were also told by everyone in the home that the child went missing on June 9th, correct?
Initially, yes. They all said June 9th.
And that included George Anthony.
That's correct.
Okay. And that later on turned out not to be the correct date.
After a few days, we were able to find out that that was not the correct date, yes.
In fact, the correct date was June 16th.
Yes.
Okay. And you had in your possession at that time all of the knowledge of this nanny, Zanny the nanny.
I wouldn't say we had all the knowledge. We had what Ms. Anthony and the Anthony family had mentioned concerning the nanny or the kidnapper. But we still had yet to talk to friends and other people that she was associated with, including these outcry witnesses, to identify who this nanny was.
And shortly after the investigation, you were able to determine that the Zanny the nanny did not exist.
I wouldn't use the word shortly after. It took a while because we still had Ms. Anthony never changed her story about the nanny. In conversations that I monitored between communication to her and her family at the jail, she was still talking about the nanny. So I wouldn't use the word shortly. Ultimately, yes, we don't believe this nanny exists, but I can't tell you or I can't pinpoint a day that I made that determination beyond a reasonable doubt.
Now, you didn't have any prior contact with anybody in the Anthony family before July 15 or July 16, 2008?
Not to my knowledge, no.
Okay. You didn't know Caylee Anthony, correct, prior to that date?
Correct.
You didn't know George Anthony?
Correct.
Or Cindy Anthony or Lee Anthony?
Yes.
And at that time, in July of 2008, you subpoenaed Caylee Anthony's cell phone records.
I had asked another detective to do so, but yes, that was on my instruction.
And you could have also asked a detective to subpoena George Anthony's cell phone records, correct?
We ultimately did.
Okay. Do you recall which time period you asked for?
I cannot recall.
You have no idea what cell phone records you requested in this case from George Anthony?
I do, and I know that we were also working in conjunction with some investigators at the Metropolitan Bureau of Investigation. And they were assisting us with a lot of things to include getting cell phone orders, court orders on particular cell phones.
The reason you requested George Anthony's cell phone records was to exclude him from the searches that were done in March, correct? Searches on the home computer?
We subpoenaed his records multiple times. We also subpoenaed for June and July.
Really? And did you give these cell phone records to the prosecutors?
Yes.
And when did you do that, sir?
I'm trying to think now. You mentioned March. I'd have to look at the cell phone records to see which ones were subpoenaed. I do specifically remember the March ones. Perhaps I'm getting confused. I'm getting confused with the home phone records. So I apologize. I don't believe I subpoenaed George's cell phone.
Okay. So you only subpoenaed the home phone records for June and July 2008, but you never subpoenaed George Anthony's cell phone records for June and July 2008.
I don't recall now.
Overrule at this point.
I don't recall.
Go ahead, you can ask the question.
I don't recall, sir.
And a cell phone record could tell you not only what calls a person makes, but their text messages?
Yes, depending on the company, some cell phone companies retain the text information.
What other information can you get from a cell phone record? Can you tell the ladies and gentlemen of the jury that?
It'll tell you calls dialed, calls received, duration of phone calls, and on particular cell phone companies, it will tell you the towers that actually carried a particular phone call at a particular time.
And what significance would that have to an investigator?
I could speak for myself. It would tell me if a particular call was placed at a time and I want to get a general area of where that phone was, that it would tell me a general area of where the phone was when a call was made.
And it could assist you in tracking a person's movements, depending on the records?
I've used it for that, yes.
Okay. And you used that for Miss Anthony, did you not?
Yes.
In fact, you had them create an entire report on that.
What do you mean they?
The Metropolitan Bureau of Investigation. You had them do a month-long investigation as to the cell tower locations of Miss Anthony, where she went, and so on and so forth.
Well, we subpoenaed the records which had that information, and at the beginning of this investigation, yes, the Metropolitan Bureau of Investigation did plug the towers in using latitudes and longitudes.
And you did not do that for George Anthony.
No.
You did not do that for Cindy Anthony.
No.
And you did not do that for Lee Anthony.
No.
Okay. The only person that you focused in on with the cell records was Casey Anthony.
At that time, yes.
Okay. At any time?
Yes.
Okay. So the entire 3 years that you've been investigating this case or had this case, you've never done that for anyone other than Casey Anthony.
That's not correct. There are other people that I've pulled cell phone records on, and I've looked at tower information to see where they were during particular times.
Who did you do that for?
Off the top of my head, I can think of one, and that was the person who actually called when they discovered the remains on December 11th.
Okay. Let's talk about that for a moment. You're talking about an individual by the name of Roy Kronk.
Yes.
Okay. Now, Mr. Kronk on December 11th is the man who discovered the remains.
That's correct.
Okay. And upon him calling, he called 911, correct?
Yes.
And
I don't know if he called it, but he called this communications. 911 was ultimately called.
that day, you immediately responded to Suburban Drive.
As soon as we were notified of the call, yes.
And when you got there, you interviewed Mr. Kronk.
Ultimately, yes.
Okay. And when you spoke to Mr. Kronk, you asked him what happened?
Generally speaking, yes.
And you asked him what he did?
Generally speaking, yes.
Okay. And you asked him if there was any other important information that he had for you regarding his activities?
Yes, this was all tape recorded in order to maintain the integrity of his conversation. So yes, it should all be on tape.
And he didn't tell you that he had called the police 4 months earlier, did he?
Objection. This is hearsay.
Sustain.
Move to strike counsel's question.
Judge, it's a negative. I'm not asking for a statement.
Hearsay.
Were you made aware at any time, or when did you first become aware, I should ask you, of prior calls to 911 from Mr. Roy Kronk?
You may continue.
During the month of August 2008, sir, were you approached by a Detective Gerald White regarding a tip off of Suburban Drive?
Yes.
And did you inform Mr. Detective Gerald White that he did not need to follow up on that tip because that area had already been searched?
Objection leading.
Sustain, rephrase the question.
What did you instruct Detective Gerald White in regards to that tip, sir?
What I recall, the tip was very general, and we had already sent a cadaver dog, Deputy Forgy, in that general area. So I told him that the area had been searched.
Okay. And as a result of which, did you instruct him at that point not to follow up on that tip because that area had already been searched?
As a result of our conversation, yes, he did not follow up on the tip, and that was because he approached me and asked me at the tip. So I told him, yes, we'd already sent people to the area, so just mark it down and go to the next tip. We were getting hundreds of tips.
Okay. Now, the The gentleman, Mr. Roy Kronk, you mentioned that you had gotten his phone records.
Yes.
What day or dates did you get his phone records for?
I can't recall off the top of my head. It would be on the subpoena when I made the request.
Okay. Do you have that with your case file?
I don't believe I have it, no.
Okay. Do you know if you asked him for, excuse me, let me strike that question. Did you subpoena his phone records for 2 weeks, a month, 6 months?
Going on memory, I believe I subpoenaed it for June through December of 2008.
And did you turn over those cell phone records to the prosecuting attorney's office?
Yes, I would have turned over all records I got on this case to the state attorney's office.
June through December of 2000?
I believe so. That was the date range.
Okay. And does these cell phone records include cell tower information?
Yes, I believe they do.
And did you have a report run for that cell tower information?
When you say report run, I make the request from the cell phone provider and they provide me the information. And when they provide it to me, I am able to actually get latitudes and longitudes based on their tower. So there's no report created aside from the one the phone company provides me.
Okay. Did you give that to the same person who prepared the report for Caylee Anthony's cell tower movements?
Who prepared the report for her cell tower movements? I'm confused. Are you referring, did I give this to MBI?
Yes, I'm asking. Okay. Did you instruct someone to observe the movements of Mr. Kronk during that 6-month period?
No, I used that information to answer questions I had about where the cell phone was at a particular time.
Okay. Now, subsequent to the remains being found, you were aware that there was duct tape found off of Suburban Drive.
I recall there were a lot of calls at the end of Suburban and in the dirt road towards the end.
You misunderstood my question.
I think I did, yes.
At the recovery site on December 11th, crime scene investigators recovered duct tape near the remains of Caylee Anthony.
Yes.
And several months later, it was made public on a news report that there was video taken of duct tape at the command center where George Anthony was manning the command center.
Yes, I remember that.
Okay. So you discovered by looking at that video that it was the same brand of duct tape.
It appeared to have the same markings as the duct tape we found on scene, yes.
Okay. And these are the markings of the Henkel logo, which is the name of the brand of the duct tape.
Yes, that's correct.
Okay. This is somewhat unusual duct tape, right?
I had never seen personally duct tape with a stamp or logo on the non-adhesive side. So to me, it was unusual. I had never seen something like that.
And when did you go back and interview Mr. Anthony as to when and why he had duct tape that was found at the scene off Suburban Drive?
I did not.
So you have never gone back after finding out this evidence and interviewed Mr. Anthony as to where he got this duct tape from and what was going on with it?
Objection asked and answered.
Sustained.
After this news report came out, you were also aware that the only piece of duct tape found at the Anthony home was found on this gas can, correct?
That had that Henkel marking, yes.
Yes. And
What?
283, Your Honor. And as far as the evidence that you had, relating to the duct tape, you knew you had duct tape near the remains of Caylee Anthony, correct?
Yes, and on her remains as well.
Okay. And you knew that duct tape was found on this can?
Yes.
And you knew that there was no other duct tape anywhere in the house that was from the Henkel brand that matched the duct tape at the scene?
Yes, at the time of our search warrants, there was none.
Okay. And the only other piece of duct tape that you ever saw, other than those two, was the one on this video?
Yes, that I can recall, yes.
Okay. Three pieces, or three different locations, three different, well, I know there were multiple at the scene, but three different locations, three different sets of evidence, correct?
Yes, generally, yes.
And you were also aware that this gas can was reported on June 24th, 2008, as being stolen by George Anthony.
Objection, leading and hearsay.
Sustained, Mr. Leedy.
During the course of your investigation, did you investigate as to whether there were any police reports maybe reporting a gas can missing from the Anthony home?
Yes.
Did you determine that this was the gas can that was missing?
Yes.
And this was the gas can that ultimately had the duct tape on it?
May I see the can?
Yes. May I approach the witness?
You may.
The tape has been removed. The tape is no longer on it. Or is it hidden under? It appears to be the same gas can on the photo. I don't see the tape on the can, though.
And you're looking at photo 107? States 107?
Exhibit 107, yes.
Now, during the course of your investigation, you actually interviewed Mr. Anthony on July 30th, 2008, correct?
I believe that was the date, yes.
Okay. And that was the first time that Mr. Anthony had informed you of some sort of a fight with Casey and this gas can.
Objection, hearsay.
Sustained.
Did Mr. Anthony at any time ever inform you that he had reported these gas cans missing?
Objection, hearsay.
I'll withdraw the question, Judge. Was the very first time you had these gas cans collected August 1st, 2008?
I'd have to refer to the property form. I wasn't the one that went to collect them. I believe it was one of our crime scene investigators.
Would you have collected it immediately after? When? Why would you have gone and collected these gas cans?
Shortly after, Mr. Anthony would have told us that.
Objection to hearsay response, Your Honor.
Sustained.
Without telling us what he told us, would you have waited a while after? How long would you have waited before collecting these gas cans after being informed of an incident?
That's a difficult question to answer, of how long I would have waited. I can't recall specifically when he first told me of the cans. I can't recall, unless I see a property form, what date the cans were collected. It would have been within a reasonable time, I believe. I wouldn't have waited months, obviously.
Okay. When you say reasonable amount of time, you mean days?
Yes, going by memory, I believe it would have been within days.
Maybe even 24 hours.
Again, without those two pieces of information, I hesitate to answer that.
Okay. Do you have that with your case file today?
I can check my report to see if it's in my actual report.
Go ahead and take a look. While he's doing that,
Were you saying the gas cans were collected on August 1st?
yes.
Reading the narrative of my report, I don't have anything on August 1st for the gas cans. So again, I would have to look at the property form just to confirm that that was it.
May I approach the witness, Judge? I have one on me.
You may.
Fortunately, Detective, I just have it all years. Does that help you?
Yes, ma'am. Yes, August 1st.
One final matter on, you said you got Mr. Cronk's cell phone records from June through December of 2008. Correct?
Yes.
Did you also confiscate his computer?
No.
Could his computer have told you more information as to his activities within those 6 months?
Stay.
Do you confiscate computers during the courses of investigations?
As a general rule, yes, if I believe the computer can provide me information related to the crime committed.
Okay. And sometimes computers can tell you what emails are sent.
Yes.
Sometimes computers can tell you what internet sites someone is visiting.
Correct.
Maybe when they do Google Maps as to locations and things like that.
Yes.
Okay. Anything that actually a computer tells you quite a bit about someone's activities on the internet, do they not?
It tells you about the computer's activities, yes.
Okay. And what else did you do to investigate Mr. Roy Kronk?
What do you mean?
You said all you got was his phone records. Did you do anything else to investigate Mr. Roy Kronk or any of his actions?
We obtained statements from him. We obtained statements from his co-workers. Obviously, we've gotten his cell phone records as well for a period of time.
Okay. I have no further questions at this time.
Cross-examination.
Very briefly, Your Honor. Detective Melich, you referred to having been provided a tip by another detective by the name of Gerald White.
That's correct.
Okay. This is a coworker of yours, or at least was at the time, in the homicide unit?
Yes, correct.
You indicated that the tip itself was very general in nature. Did it mention Suburban Drive?
Yes, it did.
Did it mention the tip itself that you saw, did it mention a particular location on Suburban Drive?
Swampy area near a 6-foot fence or across from a 6-foot fence.
Okay. Now, you were familiar at that time, which was August of 2008, with the fact that Suburban Drive was near Hope Spring Drive, where the Anthonys resided, correct?
Yes.
And at that point, in August of 2008, Orange County Sheriff's Office efforts as it related to Suburban Drive dealt with the dead end where Suburban stops just short of woods, correct?
Yes, the far east side of Suburban Drive where it dead ends at the school.
Okay. This is Hidden Oaks Elementary?
Correct.
Okay. The site where Caylee Anthony's remains were ultimately located would be between Hidden Oaks Elementary and the Anthony home, correct?
Yes, much closer to Hope Spring than it would be towards the dead end.
All right. So when you were responding initially or at least ultimately, to the tip information that was given to you from Gerald White, you believed that the end of Suburban Drive had been searched,
Yes.
correct?
Correct.
And you had mentioned Jason Forgy and his cadaver dog. Did you have knowledge as to whether or not that was the location past the school, past the dead end, that the dog had been deployed?
Yes.
Okay. That's all the follow-up I wanted to do on the testimony list.
May the detective be excused. You're excused, detective, subject to recall at a later time. Okay, ladies and gentlemen of the jury, the time is now approximately 10 minutes to the hour of 5. We're going to recess for the balance of the evening and return back here tomorrow morning at 9 a.m. Please do not discuss this case among yourselves nor with anyone else. Any additional instructions on behalf of the state or the defense? We'll be in recess to 9 a.m. Members of the jury, you may be excused. You may be seated. Okay, a couple of housekeeping matters. Mr. Baez, when is your best guesstimate of when you think you would be winding up your presentation?
At this time, we believe Wednesday or Thursday. So if I had to give a date, I would say Thursday.
Okay. State needs to have, the state gonna have any rebuttal? Do you have any idea at this time approximately how long it will take for rebuttal?
Say 1 day, but perhaps 2.
Okay. Do y'all have any idea of how long you would be asking for closing argument?
It brings up an interesting issue, Judge. The state had requested once at a pretrial hearing the request to split up the closing arguments with lawyers, allowing multiple lawyers to argue at different, I guess, parts of their closing arguments. This would essentially give the state of Florida 4 opportunities to make closing arguments. We would object to such a structure. However, I'd like the court's guidance as to whether that's going to be allowed, and then we would know how to proceed accordingly at that point. I just think 4 closing arguments is going to be a bit much.
How do you get 4 closing arguments out of the fact that the state only gets opening and then a rebuttal argument after the defense is spoken?
They're allowed to split it up between lawyers. They essentially get 4. One lawyer goes up and talks, then the next lawyer goes up and talks. That's 2. The defense, if it chose to follow that structure, would get 2. And then, of course, they could do that again in rebuttal. I think my conversation...
I don't intend to allow but one lawyer up on rebuttal. You will not split the rebuttal argument. I can understand splitting the opening argument, but there's no need to split rebuttal. So you wouldn't have to worry about that.
It's their argument as well, so they can have as many attorneys as they'd like on their closing.
Okay, getting back to my question. All I'm asking for is a guesstimate on how much time, state how much time would you be requesting. I'm not going to hold you to it now, but off the top of your head, how much time you think you would need for your closing? Okay. Mr. Baez?
I was going to be expecting less than that, but I would think
half a day or until the jury goes to sleep, whichever occurs first.
We've got lots to play, so they take that long.
Knock yourself out. Whatever time you tell me you'll need, I'm going to hold you to it. So you can speak until you get tired or the jury goes to sleep, whichever occurs first. Okay. Okay. Are y'all, I will probably give you on Monday an order dealing with closing argument. And are you familiar with a reference that I have used for years? Former Judge Ferrer's compendium dealing with closing argument. If you would like, I would email it to you. It's a very good resource. I've used it for years. It's a resource that is utilized by all of the circuit judges in the state dealing with what you can and cannot do in closing argument. But I will be issuing an order Monday, giving you some basic parameters. But if you're interested in it, I will email it to you. But it's very long. It has just about every case known to mankind, dealing with all the areas. Okay. Mr. Baez, you said there was some discovery violations you wanted to talk about?
Yes, sir. Detective Yuri Melich testified that he obtained phone records for Mr. Roy Kronk from June 2008 till December 2008. We have only received, I believe, 2 weeks of cell phone records for Mr. Roy Kronk, which I believe are June 16th through July. Excuse me. We don't have the rest. And I consider this a major violation if, in fact, Mr. Melich was testifying truthfully. He also testified that he had the phone records of George Anthony during that time period. We don't have those as well, or any of the other Anthony family members. I'm quite shocked to hear this information, and would request to find out if this is actually true, inquire by the state if they have made inquiries on this topic and where these phone records are.
State, any response?
My speculation is that the records that they may be looking for are contained on the disks of information that they've been provided. However, it's my understanding that counsel has subpoenaed all of Mr. Kronk's records, asked for a court order, and had Mr. Kronk's lawyer respond to the request for a subpoena, and the court placed some parameters on that to avoid a fishing expedition. Nevertheless, I will inquire of Detective Melich if there are items in his possession that are not what was turned over to us, he and I spent a great deal of time going through his file and comparing it to what I already had and had turned over. So I will do that. This is the first I'm hearing from Mr. Baez that he believes there's something missing. As it relates to this allegation about the Anthony's phone records, he provided those, Mr. Baez, provided those to me. So if there's something in addition to that that he thinks Detective Melich has based on the testimony, then he and I can speak about that. But I believe ultimately Detective Melich said he testified, or Detective Melich testified that he received home phone records of the Anthonys. But we can certainly compare. I am unaware of any intentional discovery violations, but I can continue to work with Mr. Baez to compare information.
Anything else, Mr. Baez?
I know we tried to get the cell phone records, but if I fully accept that, if Mr. Rainbird can double check, and then would obviously have to recall the detective to set him straight.
Well, you talk about there was some court order with Mr. Crunk's record. I guess that predated me.
It must have. I know he had asked for records from a lot of individuals. Many of them had lawyers. They had a full-blown hearing about the scope of any subpoenas. So, yes.
The rules of discovery contemplate a couple of things. It contemplates that the state provides, one, things that are in their possession that they intend to perhaps utilize in trial, reports of experts in things of that nature. There is something besides the rules discovery called Brady versus Maryland, which you file a motion, at least on 3 occasions that I can remember, asking for Brady material, which requires that the state provide any information that may be exculpatory to the defendant. The rules also provide that you have the right to subpoena certain records on your own. And it looks as though you may have subpoenaed phone records. I don't recall the state trying to introduce anyone's phone records that they did not give to you. And so that wasn't an issue during the trial. The only issue would be if those records were exculpatory, which I cannot say since I'm not familiar with the records, and the state hid them. The bottom line is if you need records, try to get them, but it's a little late in the day to be going after red herrings. But if there are exculpatory things, then you know what happens when they're exculpatory. So, and that's all I'm going to say. Anything else we need to take up?
I guess it's a requested instruction about Dr. Rodriguez. I don't know if you want to talk about that now or tomorrow morning.
That's up to y'all. I'm here.
Mr. Mason, which would you prefer? Talk about this now or in the morning?
Suggested instruction. It is, first of all, a comment on evidence not before the jury to the extent that it seeks to indicate that Dr. Rodriguez, quote, will not be resuming his testimony because his employer, the Department of Defense, will not permit him to testify in the current proceeding, is not wholly, it's not before the court. It is also not wholly accurate. I think it would be better if the court did not announce to the jury facts not before it, but if it does, the correct fact, as I know it, would be that he is not, that his testimony was prohibited pursuant to the rules and regulations of the Department of Defense. And therefore, he was testifying in violation of those rules and would not be permitted to do so. I don't think the defense wants the jury to be told that. So perhaps we should simply come up with a instruction that, in a more bland way, advises the jury that he was withdrawn because, as the court noted, the defense could have subpoenaed him and forced him to testify since he was here, and they chose, and I applaud them for not trying to ruin this man's life over it, but they didn't. So I think a more appropriate instruction would simply be something that announces that he's withdrawn as a witness, and the jury should disregard any testimony he gave, because I think that more accurately reflects the reality.
Your Honor, you may recall that it was Mr. Ashton who stood in that room with all of us and told us that he on Saturday had a phone call from the boss of the Department of Defense advising him, it wasn't Mr. Ashton's to him, it told him that Mr. Rodriguez would be terminated if he testified, and that information was not passed on to us until that part of the day after his deposition, in fact, had been taken the day before on that. And the only reasonable conclusion is exactly as we all talked about. Yes, you could have forced him to stay. Fact, I suspect if we had asked to, you could have declared him a material witness and had him put in jail to stay here.
That's true.
Sure. But obviously we were put in a situation of dealing with reality and humanity and ethics not to do any of those things. I don't want it to read it's like he just withdrew or just didn't do it, because that's not the case. Well, you were there. You heard it. So,
but it's also true, is it not, that what was represented was that he did not get the permission of them to testify. And that was the reason why.
I don't know that Mr. Baez talked to him. I didn't.
We don't know that, Judge.
Well,
all we know is this. We know that he came, he began his testimony. Of course, we had the break. He took his, Mr. Ashton took his deposition. Somehow Mr. Ashton had a phone call with the Department of Defense on a Saturday. The next day, he's shaking in his boots because he's going to get fired.
Let me clarify the implication of what counsel just said, just so it's clear. I received a phone call from Dr. Rodriguez's employer at the Department of Correction, a Department of Defense, a Captain Malik. I did not solicit his phone, his contact. He informed me that they had learned of Dr. Rodriguez's participation by seeing it on television, that it was in violation of Department of Defense regulations, that he did not seek their permission, and that he was ordered to return home. And if he testified, he would be fired. I informed the court and counsel of that in an off-the-record discussion outside as a courtesy so that the witness would not end up losing his job over this. Any implication in counsel's comment that I contacted them is absolutely 100% false.
There's also more to the story here, Judge. Mr. Ashton also requested an additional 24 hours so he could review a deposition that he just took, knowing full well that Mr. Rodriguez was in the hot seat. So we're going to have a motion in regards to that forthcoming, but this is the most accurate representation of the events that transpired with regards to Mr. Rodriguez.
Since the facts are quoting me, I think I'm the most accurate. The point is, the facts are not before the court. The court needs to simply inform the jury that the witness is withdrawn, which is factually and legally accurate, and the jury should give no regard to his testimony and leave it at that. If counsel wants to file something under oath, bring it on.
We will.
Well, the only thing I'm going to say about it is this. In order for me to craft something other than something that is based upon what I know, which is very little, is that you're going to need his captain to testify, and they don't need to do it in person. We can do it at a break after 5 or early in the morning before 9 o'clock, and Dr. Rodriguez, and we can find out, one, whether that is a regulation by the Department of Defense, and 2, whether or not the good doctor sought permission to do this. If not, because I offered on Saturday to order Dr. Rodriguez to be held over until Monday to testify, since he was in the jurisdiction of the court. And if he would have been held here on his own, and if someone had echoed that they felt that despite my written or verbal order to him that they had reason to believe that he would flee the jurisdiction of the court, then I would have ordered him held in the Orange County Jail until such time as he would testify to assure his availability. And if memory serves me correctly, the defense then said they did not want the man's job in jeopardy, that you had, quote, another witness that could testify basically to the same thing that he was going to testify to, and that you were going to let him go. So if we're going to tell the whole story, we'll tell the complete story, or tell a very mundane thing that his testimony is to be stricken, and you're not to consider his testimony, the little that he did give, and you're not to speculate on the reasons why, and it will be very benign. And I can craft that, and I will give that. And that will be end of story. I will have proposed jury instructions for you to start looking at probably on Tuesday. You can have them on Wednesday after you look at the proposed jury instructions of Thursday. The way it looks like, the defense is going to wrap up Wednesday. I would like the state to have some witnesses on standby unless they're coming from out of state, so we can get started Wednesday. And you said you would take a half a day, but probably a full day. And that means that if you take Wednesday or Thursday, and you're going to take a whole day to close. Pardon?
The openings took a full day, so I don't anticipate that the closings plus instructions would be any less.
Well,
more, but I wouldn't anticipate that the closing arguments would take less than the opening.
I'm trying to decide whether or not I want to send them out Friday evening, or whether or not I would like to bring them back in fresh Saturday morning and instruct them and send them out. Because if we send them out hypothetically Friday starting at 5 o'clock, we're gonna probably end their deliberations between 6:30 and 7 and send them back. And I have to keep them separate from each other from that point on. So let me think about that, whether or not I want to get them started or whether or not I want to bring them in and instruct them on Saturday morning. Instructions will probably take 45 minutes. But that's something I need to think about.
What lesser included offenses they want?
The
at
lesser,
some point?
yeah, y'all have an idea at this moment, the ones that I had included is depending on renewed motions for DV. Currently now what's in there are both theories of first-degree murder and felony murder. After that, second-degree murder, manslaughter, going to count two, and I'm just doing this all on memory, aggravated child abuse with the less of child abuse, battery. I'm just going off memory. I may not have battery in there. Under the aggravated manslaughter, just aggravated manslaughter, because there will be an instruction on interlocking verdicts that I would have to give them. And then there are no lessers for providing false information to a law enforcement officer. But think about any other lessers you may be inclined to ask for. But what I do is I get that to you Monday morning because I can finish that over the weekend. Okay. Did you provide the state with this new motion you filed?
You have it right here.
Okay. Madam Clerk, I'm going to ask you to, when do you intend to argue this? Set it for hearing, Reverend. Okay.
The supervisor, I'd be happy to provide it.
They can call.
Witness. I'll give to him privately. I don't want
Okay,
people.
remember, folks, that this particular motion to dismiss is an evidentiary hearing. So you're gonna need motions to prove up the allegations other than attorneys flapping their gums. That's fine. You just, it's an evidentiary hearing. I'm not gonna interrupt the trial. So you figure out how much time you need. If you need 30 minutes, then you can do it in the morning, starting at 8:25. Or if not, you can do it at the conclusion of any day's worth of testimony.
Yes, sir. We'll take the name and we're gonna, and we can inform the court when we're ready to have that heard.
Okay, anything else for the good of the order? Okay, we'll be in recess to 9 a.m. tomorrow morning. If you want to bring any matters up, notify the court deputy at 8:30. The second. So all minds will be clear for tomorrow. We will break at 12 o'clock for 1 hour for lunch, and then we'll go to about 3:30. Defense, if that's going to change, you need to let me know, because I'm going to make arrangements for the court deputies to feed the jury here. So we will stop at noon. Have somebody from your staff order you a sandwich. And we will have 1 hour, and we will start back at 1 o'clock.